Welcome to Legal Forum, the public service program of the Lawyer Referral and Information Service of the San Fernando Valley Bar Association. Today's topic for discussion is employment law. What are your rights? Dave's guests today are attorneys Sue Ben-David Arbiv and Lyle Greenberg. I am Leon F. Bennett, and now here's the host of Legal Forum, David Hagen.
Thank you, Leon. Well, employment law is certainly a topic that's important to anybody that works in today's society. Let's meet our guests. First, I'd like to start with Lyle Greenberg. Lyle is a partner at Greenberg & Sedley in Woodland Hills. His practice involves employment, insurance, healthcare, and personal injury matters. He's a past president of the San Fernando Valley Bar Association, past chair of the Woodland Hills Chamber of Commerce, and a trustee of the Los Angeles County Bar Association. Welcome, Lyle. Good to have you with us.
Thank you, David. Hi, Sue.
Hi.
Sue Ben-David Arbiv. Sue is a partner with the national law firm of Arter and Hagen. She works in the Woodland Hills office. She's the national chair of the firm's labor and employment practice group. She represents management both in consultation and litigation. She's currently a trustee of the San Fernando Valley Bar Association and co-chair of the business law section. Welcome to you, too.
Thank you. Nice to be here.
Well, let's get right down to it. Sue, tell me, what is a typical client for you?
Typical client is an employer, it's management, and I can walk in any Monday morning and have 5 frantic phone messages from clients with any matter, any problem related to employment law. They may want to fire somebody and that just have found out that she was pregnant or that he had a workers' comp claim, and how do they respond to that? Or they may have received a complaint from the labor commissioner saying they didn't pay overtime or didn't provide their break periods when they think they did. What do they do?
Now, you get frantic calls from businesses?
I get frantic calls from businesses. Usually it's HR directors or CFOs or business owners or general counsel.
HR meaning?
HR meaning human resource directors.
Typical client, typical day for you, Lyle. What is that like?
Well, it's not so typical. I get telephone calls from new hirees who want me to review employment agreements, individuals who feel they're about to be terminated and have agreements or severance agreements to be reviewed. I have individuals who have been written up and feel that it does not accurately portray what took place. Myriad of things. We have individuals who are on the low end of the pay scale to senior management who may want to leave the company and have a covenant not to compete that needs to be reviewed.
Interesting. So would it be fair to say that, Sue, your practice primarily involves representing management, and Lyle, your practice primarily involves representing employees?
That's
That's
true.
right.
And so we've got 2 perspectives to the same topic here today.
Right.
Yes, we do.
This would be interesting. Good. Well, today we have a letter from a viewer that was sent recently to the Bar Association's office. So, Leon, if you'd be so kind to read that letter for us.
Thank you, Dave. Dave, we have a letter from Gina who writes, I'm a 40-year-old single mother of 2 school-age children. I've worked for the same graphic arts company for the past 9 years, ever since the company was started. I receive a good salary, health insurance for me and my kids, and my hours are flexible to allow me to be home with my kids after school. The original owners of the company sold the business a few months ago. The new owners have started laying people off due to the economy and hired a new manager with whom I have issues. The new manager just told me that I cannot leave work so early and has been inviting me to go for drinks after work, which I've declined. The situation is so tense at work that my stomach is in knots and I can't sleep at night. I can't afford to quit. What do I do?
Well, let's start with the attorney for the employers. Lyle, what are employees? What are some things that you would do, or some things that you want to know?
Thank you for asking. I'm concerned on a personal level for Gina. From the very beginning, she's indicated to us that she's tense, she's got stomach problems, and so although it is not a legal issue, I would suggest to her that if she needs either psychological or medical care, that she address that. The next step would be to ask her, if she were to call me, whether she had signed a written employment agreement or whether it was an oral agreement. If it was in writing, I would want to take a look at that. And then I would begin to explore some of the issues and some of the facts that she had laid out in her letter, get a little more detail, and then be able to give her some insight into what her choices and alternatives are.
Well, let's talk about that oral versus written agreement for just a minute. Sue, from the employer's perspective, does that make a difference?
It does make a difference, and in our state, in California, all employees are presumed to be at will, which means they can leave at any time, and the employer can can fire them at any time. But there are lots of exceptions, and one of them is, in fact, whether you have an oral or a written contract, which says just the opposite, that in fact you can only be fired maybe for cause, and maybe it specifies the cause. So what Lyle, I think, is referring to is, does Gina, does she in fact have a contract that says, yes, you can only be fired for cause, and is the economy maybe one of those factors? Is that going to be sufficient cause?
Well, now, back before I started practicing law, I had lots of jobs. I don't ever recall signing an employment agreement. Are these agreements common?
I think that employment agreements express written agreements are more common with higher-ups, more of the executive officers and people in management. Typically, you don't have express written contracts for the workers, the people on the line, the people actually doing the production work. But I think it's a good idea for employers generally to have at-will employment contracts with all of their employees, saying in writing, saying that the nature and term of our relationship is at will, and that's it. It can never be changed. This is it. And the only way it can be changed is if the president of our company actually signs a document saying you have a contract and it's in writing.
Lyle, how about that?
I agree with Sue that the relationship should be documented in some fashion. And by the way, this employment contract that we've been talking about need not be a lengthy document. It can simply be a letter memo identifying the amount of money the individual will receive, the hours that this individual will work, and in Gina's case, this document that we've been referring to may make reference to the abbreviated hours that she had referred to in her letter. But we're also talking about a second document, and that is the employee handbook, because that document also defines an employer's and an employee's rights and responsibilities towards each other. And more often than not, there is an at-will provision in that employee handbook. But that's not the end-all of the analysis of an employee's rights relative to termination issues or any other issue that may arise in the employment context.
So not only is there a written agreement, but there's an employee handbook.
If the employer has created one.
Well, how about that? Do you create a lot of employee handbooks?
I do that all the time. I create employee handbooks, and we do expressly state that employment is at will, and that's the entire nature of the relationship, and that cannot be changed. And we also have language saying that the employee handbook is not a contract, and that the only contract is the at-will employment. And that gives the employer the discretion to change things, to change their policies, to change their terms and conditions of employment. So if the employer wants to say, you know what, now you have to start working from 9 to 5, that's a term and condition of employment that it is reserved to change at will.
Should every business have an employee handbook?
I think it's a worthwhile, if you have employees, I think it's worthwhile to set forth in writing what the terms and conditions and what the policies are and what you expect from your employees. And a good place to have that is in the handbook. It doesn't have to be 100 pages long. You know, depending on the size of the company, everyone will be different.
How about from the employee's perspective? Does an employee handbook help or hurt you in terms of making a claim or representing someone who perhaps has been terminated improperly?
That's a very good question. My preference, both as a lawyer and as an individual, is to see that there is an employer-employee handbook in every company. It makes it far easier to explain to potential clients what their rights and responsibilities are and to understand the relationship that exists.
I've got 4 employees in my office. I should have an employee handbook.
I think so. Come see me.
I'll get with it. I'll get with it. What else do you see in that letter from an employee's point of view, Lyle?
Well, there are a number of things that I would want to know from Gina, but I'm most interested initially as to whether she's had a conversation with this new manager expressing to him that she's uncomfortable with the requests to go out for drinks.
Okay, and what is that? What kind of thoughts or what kind of areas of law or potential claims does that lead you to?
Well, if she has expressed to the manager that she does not want to go out to drinks and she's uncomfortable with that, then her next step is to go to human relations, employee relations at that company, and document that fact. My concern here from a timing perspective is I would want to know when, in relation to the request for drinks and the changing of hours and the layoffs and the suggestion that terminations are taking place for economic reasons in the company, which came